14A District Court is now in session. All those having business before the court draw near. The Honorable Judge Judge Simpson presiding.
And good morning, everyone. Court does call the case of Dexter Shops, LLC versus Whiskey and Rose Tanning Studio.
Good morning, Your Honor. David Waldo appearing on behalf of Dexter Shops, LLC.
I don't have anyone signed in for the tenant.
You have nobody signed in for the tenant. I do have before me a stipulation and conditional dismissal.
That's correct.
And both sides are represented by counsel, correct?
That's correct, Your Honor.
All right, very good. Then what I will do is I will sign off on that. I will enter that. And you're all set?
You have a great weekend.
You do the same, sir.
I will. Thank you, Judge.
Let's call the case of DJM Land Company versus Mitchell.
Court is in session. Quick tip, these dockets move fast. Blink and you'll miss a settlement, a default, or a life-altering deadline. What would you be most nervous about walking into this room?
Plaintiff. I saw Mr. Kish's.
I think I do. Mr. Kish?
Good morning, Your Honor. Mitchell Kish here.
Good morning. All right. And what is plaintiff's claim in this case, including cost?
Your Honor, including costs, that would be $6,477.40.
All right. And, sir, how are you intending on getting this paid if you believe that it's owed?
I've made a partial payment. They received a check they should be in possession of for a partial payment for it, which should be leaving me a balance near $5,800. And I should have that paid within about 7 days next week on Friday.
Well, you're entitled to an adjournment on this, so I will adjourn this matter out. And you think that you're going to have the balance paid by then?
Yes, yeah, I do.
All right. I will adjourn this to May 30th, 2025 at
1 p.m.
At 1 p.m. That is an in-person proceeding. If it's not all taken care of.
Sounds good. Thank you.
Your Honor.
All right. Thank you. Court calls the case of Avalon Housing versus Yolanda Shepard.
Morning, Your Honor. Jillian Engen for plaintiff.
Good morning, Your Honor. Andrew Campbell, P64391 on behalf of Yolanda Shepard. Last night, Your Honor, I filed several pleadings, Judge. The matter is a little bit complicated, and I'm not sure if you would, if opposing counsel will be better to describe what's going on.
Your Honor, it's my understanding that there was a flood in the unit. And so I think that the parties are attempting to resolve this. However, my client needs to go in and complete repairs. And so we're trying to coordinate retrieval of Ms. Shepard's belongings. We're trying to figure out kind of how to move forward. But my client does need to get into the unit and ensure that, there's not going to be entry by Ms. Shepard. And so we filed the ex parte motion with that intent that the court would give authority to plaintiff to remove and secure defendant's personal property and then dispose of anything that was damaged that's in the leased premises.
Stipulation and conditional dismissal means both sides cut a deal and the judge signs off. If the conditions are met, the case vanishes. If not, it can snap back. Business versus business, but the real winner is time.
And
May I
what
add?
I'm sorry. Go ahead.
Yeah, if I may, Your Honor, just to add to that a little bit. We had a 10-day meeting, Your Honor, and my client was living with a neighbor after this flood. And then May 8th, the county came in and put a tag up and locked everybody out. May 9th, opposing counsel emailed me because the day before I had emailed them asking about the case. And they sent me the pleadings and also the notice to quit and the health hazard. Now, those were served, Your Honor, just so you know, on the same date that these pleadings were filed. So I filed yesterday a motion to dismiss for lack of jurisdiction and a response to the defendant's motion, as well as an answer and affirmative defenses. We are trying to work with them.
Well,
We're not.
let's deal with the jurisdictional issue. What is your jurisdictional issue?
Well, Your Honor, it's my understanding that MCL 600.5714 states a person entitled to possession of premises may, meaning it's permissible to recover possession by summary proceedings after a person holds over premises. So to hold over, you have to be served the notice to quit. If you send a 30-day notice, you got to send it, give them 30 days to comply, and then file your summons and complaint. Or in this case, they did both a 30-day TOT notice and a health hazard notice, but they sent the health hazard notice on the date of filing. And respectfully, I think that that's violating the law, because you're supposed to give them 7 days to get in. And frankly, that's hard to do so when the county has locked you out. And so the court lacks jurisdiction because the requisite requirements by the statute were not met prior to filing. And I listed all the law in my brief, Your Honor, in my motion. Ypsilanti Housing Commission versus O'Day. Plaintiff's termination notice is improper and void. And also Park Forest versus Smith, a proper termination notice is necessary for the court to have jurisdiction. And while the notice was valid in respects to perhaps the content, although we disagree with the assertions, it was not timely. It was not filed in a timely manner. And so my client never had a chance to kind of abide by the demands of the notice. And additionally, I filed a motion for discovery if the court was not going to grant it, because the fire report indicates, I'm quoting from page 1, incident type sprinkler activation, no fire, unintentional. It also states, quote, there was no fire or smoke in the building, end quote. So my client, she wasn't responsible. Apparently this sprinkler, I haven't been in the apartment because we're locked out, but it's cathedral ceilings. It's way up. My client tells me she can't even reach it with a ladder. So the sprinkler just went off and caused all this water to be ejected. She's been, and Avalon has been assisting. They did offer a hotel, but she couldn't get transportation to the kids for school, so she stayed with a neighbor. Now they're offering a hotel again, which we're grateful for, and we want to take advantage of. But my client is poor and doesn't have a lot of money and needs to be able to get a U-Haul and a storage unit. So she went to Faith in Action and should be hearing from them today.
Why are we going through all of this? It's the unit is untenable, correct?
Well, that's the conclusions they state. They're stating it's untenable, and I don't know I don't know for sure. I don't see any insurance adjusters reports. I don't see anything. There was an inch of water.
I guess I'm not even clear why we're going through this. Under paragraph 31 of the lease, the landlord wants to enter the premises to secure the premises.
Yes, but there's a couple problems with the order. And the order that they proposed, Your Honor, let me get specific. And because I've been through this before. I've been down here for 3 months, and I've seen this before. And it says, it's further ordered that plaintiff may remove and secure defendant's personal property from the leased premises. And here's the problem language. Dispose of any rubbish, trash, waste, and other water damage and or flood damaged items contained in the leased premises. That's a problem, because any maintenance person.
Then why don't you just ask that they can just look at that your client can look at it? I mean,
yeah, that's what I did in my motion that I filed.
Don't interrupt me. Why are we going through all of this? They need to get into the premises. They tag the unit. They need to get into premises. Otherwise, more damage is going to occur. both to your client's property as well as to the tenant, to the unit.
Numbers check? That total includes court costs, not just rent or damages. Viewers, would you rather negotiate a lump sum now or fight it out and risk fees stacking up?
Well,
Doesn't
I'm
make
sorry
any
for,
sense to me why we're going through all of this.
I'm sorry for
If the
interrupting.
issue becomes the destruction or the disposal of property, then certainly I think council should be able to arrange that as the property's being removed, your client can be there to try to salvage what property is salvageable.
May I speak, Your Honor?
Go ahead.
I apologize for interrupting the court. Judge, there's a lot of issues in this case. If you look at my motion, my response, the problem we have is we want that, Your Honor. We asked at the 10-day meeting for opposing counsel to contact the county and get the county's schedule when they can come out and open the door for my client. And my client can then go in. Nobody can enter without the county's permission, Judge. Okay? That's what we want. But what we don't want is we don't want some maintenance person looking at the goods and saying, oh, that's water
Well, why
damage.
don't you and council get together, contact the county, and arrange a time to go down?
I agree.
What is so hard? What is so hard about that?
There's nothing hard, Judge. It's not on me to do that, Judge. It's a plaintiff's case. And we had a meeting. And I have
Counsel. Your client has property that she may want to salvage. It would seem to me that it would be in your interest to contact plaintiff's counsel, get with the county, figure out a time that the parties can go in there. It's in all parties' interest to do that. Your client, the landlord, everybody's interest to get into the unit, get out those items that your client that are salvageable, allow the landlord to go in, repair what's there so that further damage doesn't occur.
I agree. And that's why we had a 10-day meeting.
All right,
I don't understand what I'm not seeing.
Here's what we're gonna do. I'm adjourning this to next week. Between now and next week, I'm gonna order that council get together with the county, arrange a time to go into the premises for inspection of the premises and removal of those items.
Thank you, Your Honor. And so at this time, I just want to clarify, Your Honor, you're not entering the ex parte order as drafted.
I'm not going to enter that order. I'm going to enter the order directing the parties to get with the county, to gain entry to the premises. That defendant is to remove those items that she wishes removed.
Thank you.
And then plaintiff is also able to secure the premises and stop any further waste on the premises.
Thank you, Your Honor. Two things briefly, Your Honor. We would like to reserve escrow or preserve escrow from today's date. Also, the case was filed under 657-14 1C 1i after termination of the lease pursuant to a power to terminate provided in the lease or implied by law. Obviously, we can talk about that later. I just want to have that on the record.
Well, that's why I don't see the jurisdictional issue, because I think it's properly filed pursuant to the provision in the lease, but we can argue that at another point. But I'm ordering that, and I'll set this for May 30th, 2025 at 3 p.m. That's in person.
Thank you, Your Honor. Would you like us to submit an order to the court in accordance with?
Please.
In person didn't mean I was supposed to be here. I wasn't even supposed to be here.
Thank you. Glencoe Hills versus Justin Jefferson.
Jillian Engen for plaintiff.
Don't have that checked.
Justin Jefferson. There is no response. And I also should say, is it Unganchuku Nasiki? No response. If you'd raise your right hand, I'll let you proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $3,494.56. Court costs are $212 for a total of $3,706.56. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. Do I have this after June 2nd?
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ issue in 10 days. Court calls case Glencoe Hills versus Devonta Jackson and is it like China?
It's LaChina. You can call me China.
Say it again for me.
It's LaChina. You can call me China.
Okay, it's LaChina. Okay, I'm sorry. I didn't know where to break apart the syllables. LaChina Williams.
You got close enough.
Okay. All right. What is the claim in this case?
Your Honor, I have a balance including court costs of $1,818.50.
And LaChina, when are you going to get that? How are you going to get that paid?
I can get that paid by the 1st.
By the 1st?
Yes.
Okay, so here's our problem. I can adjourn it out a week, but the 1st, June rent is going to click in.
Is the 30th okay?
Can you pay it on the 30th?
Yes.
Okay. Here's what we'll do. I'll adjourn this out to May 30th, 2025 at 3 p.m. That's an in-person hearing. So can you get that paid? Can you get that balance paid, say, before noon that day?
Yes.
Okay, fantastic. Okay, so if you get it paid before noon, then what likely will happen is that plaintiff will dismiss the case. But you may want to check with them, make sure you got everything paid.
Okay.
Okay?
All right. Thank you.
Thank you. You have a great weekend.
You too. Bye-bye.
Adjournment alert. Tenants usually get at least one reset to pay or prep. Strategy play? Use the time to get proof of payments, line up assistance, or propose a realistic schedule. What would your plan be in 7 days?
Court calls the case of Glencoe Hills versus Daniel Worth.
Jillian Engen, plaintiff.
Hello.
Hello, Mr. Worth. Do you have a camera?
Yes.
Okay, I'll need you to turn that on, but while you're doing that, oh, you got it on. Okay, what is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $3,067.63.
All right, Mr. Worth, how are you intending on getting that paid?
I have a payment plan that covers next month rent, but it wouldn't be, my balance would be at 0 by next month of the 30th.
Okay, have you talked that over with your landlord?
Yeah.
Your Honor, I don't know that plaintiff is willing. I don't know if we're willing to do. I don't know if plaintiff is willing to do a COD on this one. I can ask my client.
All right. So here's what I'll do, Mr. Worth. Is there anything you can pay between now and next week?
I could do, what does next week fall on?
The 30th of May.
I could pay $1,500.
1,500 by that day?
Yeah.
Okay, so let's do this. You need to pay 1,500 by the 30th. I want that paid before noon on that date, okay?
Okay.
Then I'm going to adjourn this to May 30th, 2025 at 3 p.m. That's an in-person hearing. And then we'll see where we go from there, okay?
Could you do could you do June 2nd for the first payment?
I cannot.
Okay.
Because if you're not gonna, if you can make the payment, you need to make the payment, sir.
Okay, I'll make the payment. I could make it by June 2nd without 1,500.
All right. Well, I'll put that in the file, but I'll still need you here then on the 30th
Okay,
at 3 p.m.
okay, thank you.
You. Glencoe Hills versus Daniel Reynolds.
Jillian Engen for plaintiff.
Please.
Here.
Mr. Reynolds?
Yes.
Okay, there you are. All right. What is plaintiff's claim in this case?
Your Honor, I have a balance, including court costs of $2,068.70.
All right, Mr. Reynolds, how are you intending on getting that paid?
So approximately $750 I could pay by Wednesday of next week, and most of that today. And then that will leave me with my normal rent for the month of May, which I can make another partial payment on May 30th, but it wouldn't be the full amount of May on May 30th. I'd need approximately a week to 2 weeks to catch that up. And then I know I'll be due for June.
Hold on a second. You're going to pay $750 by the 28th. That's next Wednesday.
Yes. And that'll just leave me with May.
Okay. And then on the 30th, how much did you say you're going to pay?
I'll be able to pay roughly $600.
Okay. And then $600 on the 30th. I'd like that paid to the landlord before noon. Okay.
Sure thing. Yes.
And then I'll adjourn this out to May 30th, 2025, 3 p.m. That's in person. So then we can see where we can go from there, okay?
Your Honor, would it be possible for an alternate viewing? I will be in Chicago on next Friday.
Okay, that's the time that I've set it in person. You could submit a form to the court requesting a Zoom hearing, and then we'll consider that.
Okay, and what is the best way to submit that? Do I go to the court, or is there an electronic version I could use?
I can put my email in the chat.
You can, my coordinator will put her email in the chat, and so you can make that request directly there, okay?
All right, thank you.
Thank you. Gulfside Lakes versus Sarah Brown and Jalen Brown.
Jillian Engen for plaintiff.
Good morning, Your Honor. I'm here.
Good morning. Your name?
Miss Sarah Brown.
You're Sarah Brown. Okay.
Yes.
You got it? Okay. And what is plaintiff's claim?
Your Honor, I have a balance including court costs of $3,473.47.
All right. And ma'am, how are you intending on getting that paid?
That's not the cost that I have. I don't know if they received the $2,400 that I paid last night.
We wouldn't.
Okay.
No.
Okay.
You would not have. So you paid $2,400 last night?
Yes.
Okay. So I'm going to indicate that was the 22nd. You paid that.
Yeah.
And then, so that leaves you about 1,000 and some change. So when were you going to get the balance paid?
I could pay the balance by either in the evening on the 30th or early morning on the 31st.
Okay. So it looks like there may need to be a COD if you can't get it paid by noon on the 30th is what you're telling me.
I can try. I don't want to make that promise because my money hit different times, if that makes sense. I'm sorry.
No, that makes sense. I got you.
Because sometimes it hit earlier in the day, then it'd be in the evening. It's crazy times. I'm sorry.
Okay. All right. So here's what I'll do.
Okay.
I'll let them try to get their accounting and get your ledger all caught up. I'll adjourn this to May 30th, 2025, 3 p.m. That's an in-person hearing. And then we'll try to figure out how we're going to work it out if it's not paid by then.
Okay. Get that? May I get that balance again she has so I can minus the $2,400 from it so I'll know what I owe, if that's okay?
Yep. Yes. And I have $3,473.47. You can also contact Melissa.
Okay.
She'll give you
Okay. Yeah. And I'll definitely try to have that paid before 3:00 on the 30th. Thank you, Your Honor.
All right. All right. Thank you.
Uh-huh.
Gulfside Lakes versus Lakia Williams and Karan Williams.
Jillian Engen for plaintiff.
Hello, Your Honor.
Hello. All right. And Ms. Williams, do you have a camera?
Yes, hold on.
All right. I'll need you to turn on your camera. And what is plaintiff's claim in this case?
I have a balance including court costs of $3,593.26.
All right. Ms. Williams, how are you intending on getting that paid?
So I can have about 593 next week, but I am also in the process of working with Hawk.
Okay. So you're working with Hawk?
Yes, I had an appointment with her
Do you have an
yesterday.
appointment with them yet?
Yes, I had one yesterday at around 1
Oh,
p.m.
you did?
Mm-hmm.
Okay. They haven't indicated anything then to you?
No, what was her name? I think Alicia. She said she's
Okay.
working on it.
Okay, so here's what I'll do. I'll adjourn your case out May 30th, 2025, 3 p.m. That's an in-person hearing, and hopefully we can have some news from Hawk. Try to figure it out. I suggest that you make the payment that you're going to make so that if there's funding there, you'll be below the limit that can get paid, okay?
Yes.
All right. Okay.
Thank you, Your Honor.
Thank you.
Pardon me, Judge. Could you ask
Yes.
your administrator to clarify the email address that she put in there? I've sent a question. It's a little confusing. Thank you.
Who's
I've already answered his question.
I think she answered your question, sir.
Thank you.
Gulfside Lakes versus Alicia Sarr.
Jillian Engen for plaintiff.
She's here. Sarr?
Hello.
Hello, there you are.
Hi.
Okay. Hello. What is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $219.14.
$219.14.
Yes, sir.
Okay. All right, Ms. Sarr.
Yes.
When do you think you can get that paid?
So I made a payment arrangement to pay the rest of it tomorrow with the landlord.
Okay. So you're going to have everything paid. If I adjourn it out a week, everything should be paid.
Yep.
Okay. Then let me do that. I'm going to adjourn this to May 30th, 2025 at 3 p.m. That's in person. But if everything's paid, it's likely they'll dismiss the case and then you don't need to appear.
Okay. Thank you.
Okay. All right.
Yep.
Take care. Have a good weekend.
Thank you too.
Court calls the case of Gulfside Lakes versus Erica Hall.
Jillian Engen for plaintiff.